to Broadband Breakfast Live Online for Wednesday, January 25th, 2023. We're almost past January, so we're almost out of the woods on that 2023 date. Got to get that in your brain so you remember it. We have a very exciting program today focused on Section 230, Google, Twitter, and the Supreme Court, a series of 2 blockbuster cases, which, as you'll see from the dialogue, is really 4 blockbuster cases that the Supreme Court will be considering that directly impact Section 230 and the tech industry. But before we get to that, I want to say a couple of quick items with all of the news happening around big tech, around privacy, around competition. Now is a great time to mention what Broadband Breakfast is and does, and how we see ourselves in this process. We're a news and events company. We focus on better broadband, better lives, both the infrastructure piece and the applications in use, as well as the big tech and applications and their impact on our lives. And so we've been covering Section 230 very aggressively for the last 3, 4, 5 years as it's become more and more of an issue. And we excited to announce our conference, the Big Tech and Speech Summit, that will take place on March 9th of 2023. This is available on our website. Just go to broadbandbreakfast.com and go to the right, conferences. It's the top one listed, or just click on conferences. I'll put the URL in the chat stream for those of you watching here on Zoom. For others, just broadbandbreakfast.com/BTSS for Big Tech and Speech Summit. This event on March 9th will drill into not just Section 230, which we'll be talking about today, and social media and content moderation, and what we're framing as the fragility of Section 230. That's panel 2. Backing up a second, panel 1, the big picture for big tech, right? And I don't need to explain that, Silicon Valley is no longer the favored child. I mean, with everyone from right-wing Republicans to progressive Democrats, and now the Biden administration really putting their foot on the scales against some big tech companies. What and why has this changed, and what is the big picture for information technology companies? We'll talk about the fragility of Section 230, which I mentioned, which has been called the 26 words that created the internet. And today's free panel on our Broadband Breakfast Live Online show will really drill into that. Really, what is Section 230? Why does it matter? Is it going away? When? How? Etc. That will be considered in a special in-person session. These panels will all be in person only at Clyde's of Gallery Place in Washington, D.C., although we'll be recording it and making that available to members of the Broadband Breakfast Club afterwards. Our panel 3 at that conference will be on regulating data privacy, and panel 4 on innovation, competition, and future tech, right? And obviously nothing says innovation and competition like a big antitrust lawsuit as we see today or yesterday. So with that, I want to actually say one more preparatory word. We do this event, these free events on Broadband Breakfast Live Online every Wednesday at 12 noon Eastern time. So it's late enough that you can still have breakfast on the West Coast and be part of our discussion. The upcoming events next week, February 1st, we'll be talking about what will the 118th Congress do on broadband and big tech. The week after, February 8th, we'll be talking about the Build America, Buy America laws' impact on infrastructure. The following week, we'll be talking about state broadband offices and how they are approaching the next phase of Infrastructure Investment and Jobs Act. We'll be talking about workforce development on February 22nd. And then on March 1st, we will be releasing a report in advance of our March 9th conference, Big Tech and Speech Summit. So please go to Broadband Breakfast in the free events tab, and you can see all of our BBLO, as we call them, Broadband Breakfast Live Online events. And I do want to point out, we would not be able to do these free events without support from our sponsors. I want to give a shout out and a thanks to all of the sponsors of Broadband Breakfast. They include Utopia Fiber, Broadband.money, Google Fiber, Broadband Now, Lightbox, the Wireless Infrastructure Association, GeoPartners LLC, Ookla, Michael Baker International, Pinpoint Capital Advisors, Bitstream Communications, Positron Access, the California Emerging Technology Fund, and broadbandtoolkit.com. We thank our sponsors for their support. All right, with that, let's go ahead and open our view up to everyone on our panel. If you're not on the panel, please ask that you turn your video off. Let me just guide you to the great voices we'll be hearing from. We're going in the order that they're listed on the event page. Chris Marchese, I hope I got that right. He is counsel at NetChoice, and Chris analyzes technology-related legislative and regulatory issues at the federal and state level. Section 230 is key to his portfolio, and NetChoice, along with CCIA, are parties to two of these cases, the Florida and Texas social media cases. Now, we aren't necessarily focusing immediately on those, but those are definitely part of the mix. So we're very glad, Chris, that you can be part of this. After I introduce all of our panelists, we'll turn to you, Chris. Following Chris, we're going to hear from Ari Cohn. Ari, previous panelist on Broadband Breakfast Live Online. Thanks for being with us again, Ari. He's free speech counsel at Tech Freedom and is a nationally recognized expert on First Amendment issues and has been quite involved in First Amendment issues for other organizations, including Individual Rights Defense Program at the Foundation for Individual Rights and Education. Very excited to hear from you about Tech Freedom's perspective. Following Ari will be Jessica Deer. Jessica is the director of Ranking Digital Rights, also another prior Broadband Breakfast Live Online panelist. Jessica, thanks for your shout out at Mountain Connect when you were interviewing Attorney General Phil Weiser. It was really great to have you on our show. And I just really look to Ranking Digital Rights because you've been really trying to get into this tech and telecom companies and how you really manage and consider what they're doing on free speech issues, on privacy issues, on all transparency issues. These are great questions to be answering in a systematic way, the way Ranking Digital Rights is doing. So thanks for being with us, Jessica. We will then hear from Ali Sternberg. Ali is the Vice President of Information Policy at the Computer and Communications Industry Association, and she focuses on intermediary liability, copyright, and other areas of intellectual property. And as I mentioned before, CCIA is parties to the Florida and Texas cases. And she's also reminded me that they filed amicus briefs in the two cases we'll be talking about. First and foremost, the Gonzalez v. Google case and the Twitter versus Taamneh case, both kind of coming up for action by the Supreme Court. Merits arguments February 21st, February 22nd. So those are really just in the front of us here. So after we hear from Ali, we'll hear as batting cleanup our last panelist, Marshall Van. Oh boy, I don't know how we say it. Marshall. Marshall is the Questrom Chair professor at Boston University, and his work explores how information technology affects firms, innovation, society, and is really delved deeply into the Section 230 issues. So we're really glad to have you with us. Thanks for making time, rearranging your schedule to be part of our program. Without any further ado, let's turn to you, Chris. Tell us a little bit about the Google, the Gonzalez v. Google and Twitter versus Taamneh case, and also the other cases that are going to come up very soon.
Absolutely, Drew. And thank you for that introduction. And big thanks to Broadband Breakfast for hosting this great event and to the audience for tuning in. As Drew alluded to, this is a pivotal year for online speech. This term, for example, the Supreme Court will interpret and apply Section 230 for the very first time in Gonzalez versus Google. In that case, there were nearly 50 amicus briefs submitted, and I think that reveals just how vitally important Section 230 is, not just to establish services like YouTube, but also to small businesses, online advertisers, and most importantly, just average American users. But since this panel will likely spend considerable time discussing Section 230 and Gonzalez, I thought I would focus my opening on kind of giving a sketch of the legal landscape for the First Amendment implications of the Supreme Court cert petitions that CCIA and NetChoice have pending. First and foremost, NetChoice and CCIA, represented by co-panelist Ali Sternberg, and NetChoice have two cert petitions pending, one against the state of Florida and one against the state of Texas. We first sued Florida in 2021 after the state enacted the first of its kind social media must carry law. This was a consequence of, I think it was something like 200 platforms kicked former President Trump off after January 6th. And Florida, under Governor DeSantis, decided to take the lead in trying to do something about that, exercise of editorial discretion. And so Florida was first, but just a few months later, Texas came up with its own must-carry law. And while it was the second of its kind, it was no less unconstitutional. And so while the laws do differ in their specifics, they have the same end goal in mind, which is to have as little to no content moderation online as possible. So in a nutshell, Florida's law, which is known as SB 7072, would require covered entities, including ones that you wouldn't necessarily think of like Etsy, to host all or nearly all content from so-called journalistic enterprises, which is basically defined as anybody who has a small following on the internet, which, as we know, even bots have a following on the internet. And it also includes, and it also requires the hosting of all speech from political candidates, which is also broadly defined. So whether it's political candidates, journalistic enterprises, or average users, the Florida law also requires consistent moderation. That is left undefined, and it is, kind of an open question as to how one even gauges whether something is consistently done or not when it comes to content moderation. Texas's law, which is known as HB 20, would also prohibit covered entities from engaging in so-called viewpoint discrimination. In other words, if a social media service allows coverage of Russia's invasion of Ukraine, it would also be forced to disseminate Russian propaganda about the war. So if you allow conversation on a topic, then you must allow all viewpoints on that topic, no matter how horrendous those viewpoints are. And also it has the absurd consequence of transforming American social media businesses into organs for Russian propaganda. I think that's absurd. I think everybody agrees that's absurd, and yet that is the law. In the Florida case, the 11th Circuit ruled unanimously in our favor. In fact, all three judges were Republican appointees, if that is something that matters to you. And they unanimously held that Florida could not violate website's First Amendment right not to be compelled to host and disseminate all speech from other people. They also held that websites have a First Amendment right to editorial discretion, which includes the right to moderate content. The panel stopped short from holding the entire law unconstitutional. A few transparency provisions were basically held potentially constitutional, and the court wanted to see some more argumentation on that. But setting that aside, in the Fifth Circuit, where our Texas case headed, it was a split 2-to-1 decision where the court, to put it politely, ignored decades of binding precedent and ruled in Texas's favor. To say the Fifth Circuit's opinion stands out for its originality is probably an understatement. In any event, both the Fifth and the 11th Circuit's decisions are on appeal to the U.S. Supreme Court. All parties, Texas, Florida, CCIA, and NetChoice, agree that the court should grant cert in these cases. In fact, just this week, the court asked the U.S. Solicitor General for her views on whether to grant cert. This is actually a really common practice in high-profile cases, and we expect that when the SG does weigh in, that she will do so on the side of the First Amendment, which is just a clever way of saying on the side that we are on. And we are confident that even though these issues are relatively complex to government actors in the sense that, on the one hand, they might want to rule against Florida and Texas because they're Republican states, but on the other hand, we do anticipate that the Biden administration recognizes the First Amendment implications here and so forth. But either way, when the court eventually does hear our cases, the court will end up establishing probably the most important precedent for how the First Amendment applies to the internet. I would say that, Reno versus ACLU has already kind of closed this. The Supreme Court has already said the First Amendment applies fully to the internet, but it might be that we need a reminder of that. And so hopefully our cases will establish that not only does the First Amendment fully protect online speech, but there are no ifs, buts, or other types of weird exceptions to it. In that vein, we are obviously hoping that the court will follow the 11th Circuit's well-reasoned opinion, which is deeply rooted in case law and relies on very strong analogical reasoning, whereas the Fifth Circuit's opinion guts the First Amendment and more or less says it protects only against prior restraints. That should scare us all, because no matter what the outcome is in our Supreme Court cases, ultimately the ruling will have an effect outside just our immediate members and the internet. It will probably end up, affecting millions of Americans and their ability to express themselves online. So with that high-level summary in mind, I'll close my remarks and just add that happy to dig deeper during the Q&A. And thank you again for having me today.
Wonderful. Thank you very much, Chris. Let's turn now to Ari.
Thanks, and thanks so much for having me. I will try to keep it brief so that we have more time for the panel. I'm going to focus a little bit more on the Gonzalez case because Chris did such a great job of running down the net choice cases, as one would expect him to do. I think that the Gonzalez case kind of presents a confluence of two trends we see in the dialogue around tech. The first is moral panic. Moral panic over expression is nothing new. I mean, romance novels, movies, music, comic books, tabletop role-playing games, video games, what have you, have all allegedly destroyed the moral fabric of our society and handed the reins over to the worst elements of humanity. So, I guess we're doomed either way. Now, the new boogeyman in the dumbest timeline possible is algorithms. Something that many people, including the people responsible for making policy in this country, don't even understand. And that's kind of the second thing in the confluence, is that the technological illiteracy of, how the internet works, what algorithms actually do, and why they're important. And lost in a lot of this is the fact that algorithms, to at least some extent, are largely a mirror. They reflect the judgment of the programmer over what we might want to see based on what we have told it about ourselves, what we have searched for, what we have watched, all of these things. In a lot of cases, if we're mad about what the algorithm is showing, we are really mad at ourselves for telling it to show us that stuff. And that really gets lost in a lot of this. And it's not particularly a legal point, but it's something we should keep in mind. And given their way, the plaintiffs and the federal government apparently would seemingly turn the internet into a big pile of unusable mush. You have the Biden administration chiming in on the Gonzalez case, effectively saying out of one side of its mouth, search engines should be protected, but out of the other side of its mouth saying, well, YouTube should be liable here, like it would be if it recommended videos from another website, which is literally what search engines do. And Google's legal team did a great job of hammering at that in their brief. And it's kind of, I'm uncertain about what the plaintiffs and their counsel are really after here in terms of them shifting their question presented between their cert petition and their merits brief. But it kind of seems like they might be playing to some of the justices' stated willingness to monkey around with Section 230. And that's dangerous for a lot of reasons, not least of which is if we can't search for things and have them ordered for us in a way that makes sense and gives us relevant information, the billions of pieces of content out there, definitely more than billions, but I don't have a number, would be just thrown at us, just completely at large, and we'd have to find our way through it. Now, I remember back in the early-ish, I'm not that old, days of the web, clicking around through the Yahoo directory, where it organizes websites based on particular topics. And you'd click on a topic and you'd get a list of websites that Yahoo had directoryized. I don't know what word I'm looking for there, into that category. And you could click around and explore, the vastly more limited than now pages in that category. And fundamentally, that is what these recommendation algorithms are doing, just in a more advanced and technologically progressed way. And the government and the plaintiffs, they just don't present any real way to distinguish between what they think there should be liability for, quote unquote, targeted recommendations, whatever that means, because when you type a search into Google search, the responses are targeted to what you have put in and maybe even your location. When I search Google for pizza, it shows me targeted recommendations in pizza restaurants in Chicago, particularly in my neighborhood. That is a targeted recommendation. They can't distinguish between that and literally anything else involved in structuring how content is located and organized on the internet, which is essential to make it usable. But beyond that, I think even if you kind of strip those arguments away, there is an underlying question that we should ask. And that is, do we want there to be the kind of liability that they are asking for? Not do we want the platforms to have an early escape hatch. I want to know, do we want there to actually be that underlying liability? And to just give you an example, one of my favorite independent booksellers here in Chicago is my favorite because I walk in, I give them 3 books that I've read recently, and I tell them what I've liked about each book. And their staff is so good that they come back to me with 2 books that I end up loving every time, 100% success rate. They are really good at knowing books and how to suggest them. Okay, say a troubled young man walks into that bookstore and says he's read other books about, say, the Weather Underground, and is interested in anti-fascism. And the bookstore suggests a book or 2 about anti-fascism. And one of them, the author suggests that his view that violent struggle against rising fascism and government authority is not only inevitable, but necessary. Well, that guy goes to Atlanta and throws a Molotov cocktail at a cop car. Should the cop's family, or the cop, if he survives, be able to sue the bookstore for recommending the book from which this guy drew an idea? Unsurprisingly, this has been litigated in a number of different contexts. And in pretty much all of them, the courts have said we can't impose liability for, even against necessarily the book publisher who the author used for the communication of bad ideas. You hold the person who commits the wrongful act responsible, and that's it. There's no such thing as negligently pointing to someone to bad information. If I tell my friend who's been diagnosed with cancer that I read this great book about how you can cure cancer by smearing cream cheese all over your body every day, and she dies of cancer, her family can't sue me for suggesting that book to her, nor should they be able to. I should feel bad about myself for reading such a book, but that's a different story. So there's a lot of questions that go beyond Section 230 in that we have to really ask ourselves whether the underlying liability is something that's good and proper. And with that, I'm definitely above 5 minutes, so I'm going to stop.
All right, let's go right into Jessica.
Great, thanks, Drew. Fascinating comment so far. So thanks for having me, and thanks to all of my co-panelists. So I'll start with just saying a little bit about Ranking Digital Rights. We are a nonprofit research program based at the New America Foundation. And what we do is evaluate what we call the world's most powerful digital platforms and telecommunications companies according to a set of pretty rigorously created human rights standards. And we evaluate their policy disclosure. So it's sort of an open source intelligence. It's that we evaluate policies that are out and open on the internet, terms of service, privacy policies, according to standards in 3 categories: corporate governance, freedom of expression, and privacy. And our aim in doing this, and from our evaluations, we create scores and then rankings. And the aim in doing this is to establish sort of a baseline understanding of transparency that these companies are sort of putting out there about how they operate, what their policies are, and how they're upholding their obligations to promote and respect human rights. As well as trying to incentivize sort of a race to the top where companies can actually compete on their respect and protection for human and civil rights. So we're a very technical project and have a lot of we're very methodical about how we're thinking about things. So in our indicators, many of which are sort of related to the Section 30 debate, we ask, particularly in our freedom of expression indicators, about access to policies, whether or not users are notified of changes, what are policy enforcement processes, which is basically what are the content moderation rules. We ask for data about policy enforcement, or whether or not companies actually disclose data in their transparency reports about policy enforcement, as well as data on third-party requests, such as from governments or private entities. And we also have a set of indicators that are about algorithmic system development and use policies, targeted advertising policies. We ask for disclosures around that, and disclosures around how users' online content is curated, ranked, or recommended. So we're sort of taking a snapshot every time we do a ranking, which is around once a year, although we're taking a slight pause at the moment in our Big Tech Scorecard, which so we publish our results in the Big Tech Scorecard, and we do some analysis and sort of trend finding. And I'll get into a little bit of that as we sort of talk through a little bit more of the Section 230 cases that are ongoing. As I mentioned to my co-panelists, I am not a lawyer and will not provide any legal analysis of these cases, but I'll try to sort of use their analysis to explain sort of RDR's position on Section 230, which basically is that it should, in the simplest terms, it should be considered sort of bedrock law and a foundation on top of which we think other types of regulation and law can be articulated and built. That to go in and sort of try to, take a jackhammer to this foundation of the internet to get to solve some of the problems that weren't even in existence at the time that it was written is really kind of a backwards approach to things. And that what we should really be thinking of is thinking forward about what new policy changes that we need to make, and use data such as from our index and other places to actually sort of make strong proposals around that. I agree that I think the Google versus Gonzalez and the Taamneh case both are really odd in that they're both sort of focused on this on terrorism in 2 different ways. My understanding is that there's not specific pieces of content or even users that are sort of implicated in this. So I'm hard pressed to understand why we would use such extreme sort of circumstances to try to design how the internet works going forward. So I don't understand that rationale for accepting those cases. Hopefully some of the people on the panel have a better insight into that. And I think basically until algorithms can really detect the difference between illegal speech and legal speech, that they're always going to be very fallible, and that we have to sort of think about how we regulate and correct for that. I also wonder, and I actually asked this as a question to the panelists, like to what extent does intent really matter in terms of what the companies are doing and how liable they can be held? Because it seems much to the point that Arthur was making, that recommendation algorithms are not representative of the intent of any one person, but really are a reflection of how we interact with, not just how we interact with platforms, but what data platforms take from those interactions and the assumptions that they make about us and what kinds of content that we would like to see. And as a transparency project, one of the things that we would recommend, and I'll go through some of our sort of recommendations very, very quickly, is that there is a lot more transparency about how companies are enforcing their rules, that transparency is data that is released within transparency reports that could actually give us some idea of how they're actually moderating their own rules. We know a lot about sort of what they do with government demands and other aspects of things, but not really about how they are enforcing their own rules. I think removing Section 230 protections ultimately just outsources more of our public sphere to companies, and sort of just isn't fit for purpose for the way that we live and engage with each other today. So just really briefly, the things that we think we should do: more disclosures and transparency, specifically around how algorithms are developed and data about enforcement, as I was mentioning. I think also we should take a more methodical approach to evaluating what the impact of law and policy will be on the internet sphere. We ask for human rights due diligence or civil rights due diligence from the companies in terms of their tech systems. And we also ask them to evaluate in our indicators sort of due diligence around what are the legal frameworks in the operating environments, where they work. Or where they operate. And so we need more methodical and independent sort of human rights and civil rights impact assessments of what removing Section 230 or what amending Section 230 would do. I think a lot of what's happened over the past several years has become sort of a political football or a partisan football. And it would be really to our advantage to actually think through methodically what would the impacts be on which people and for what reasons, and what do we want to control and modulate, and what are we willing to not willing to do. I think we've got to pass privacy legislation. The data collection and the recommendations and ranking systems is really the less data they have access to. Maybe it's a little bit less personalized, but that's okay. We need to sort of, as a society, sort of figure out where we are on that and really push for privacy legislation. And we need to regulate online advertising. It's much easier, we think at RDR that it would be, not that it is easy, but it is much more feasible to regulate online advertising as content. You don't have, as I understand it, the same First Amendment protections, and because it is paid speech, and that being able to understand how to regulate online advertising, which is really the central reason why companies moderate content in the first place, is to generate profits, would be a smarter approach. And in a later comment, I can talk about how we would like to, some ideas about how we like to do that.
Okay, awesome. Thanks so much. Let's go right into you, Ali.
Hi, everyone's name is Ali, and I really appreciate the opportunity to be here today back at Broadband Breakfast, along with our co-plaintiff NetChoice and other colleagues who I will try not to repeat. So just a quick recap about these really crucial 230 and First Amendment cases that are being considered right now. So as noted, this is the first time that Section 230 is before the court. In the Gonzalez case, oral argument will be held next month, and a decision is expected before the end of the term. There's also a related case, Tomna, which doesn't explicitly mention Section 230, but it overlaps in some ways that we'll get into. Just, I think last week, the briefs came in, the second round of amicus briefs came in. They were nearly in the Gonzalez case. And because this is so, Section 230 is so important to the internet and to speech and to every website, there were nearly 80 amicus briefs filed from government, industry, and civil society. There were 48 in support of respondent Google, 19 in support of petitioners Gonzalez et al., 11 in support of neither party. And then the United States government is also a party to this case. They filed in support of vacatur and requested to participate in oral argument. So we're still going through all these briefs, but a lot of them seem to fall into three main buckets. The majority, that 230 is working and does not need to be changed. Some that the court shouldn't touch 230, but maybe Congress may want to consider reforms. And then finally that the court can do something about 230. And so as has been noted, these cases are kind of in tension a bit, because the cases that are already granted allege that internet companies are not doing enough. And then our two pending cases, the Florida and Texas cases, involve accusations that internet companies did too much to take down bad actors online. So, and then as noted, on Monday, the court asked for the views of the Solicitor General in our two cases, which is a good sign, but likely means that these cases will not be considered until next term. And also our cases are our First Amendment cases rather than 230 cases. Do want to focus on that as my colleagues have. So in the Gonzalez and Tomna cases, they both involve claims under a statute called the Anti-Terrorism Act. And do not an expert in that, but I just wanted to emphasize that no one wants to see this horrible extremist content on digital platforms, especially the services themselves. Responsible services invest a lot into upholding their terms of service and promoting trust and safety. And there's also business reason that involving advertisers as well. But there are a lot of incentives from all sides that do not want to have horrible, dangerous content involving all kinds of varieties of lawful but awful speech, as sometimes it's called. So the same mechanisms that push up relevant content to benefit users and small businesses, they're also like they're kind of on the flip side of mechanisms that push down dangerous or even illegal content. And so the act of recommending something is also the act of not recommending something else. And so wanted to mention that part as well. I'm going to repeat that. Yeah, so and these two cases, as I said, they're both involving families of victims of terrorism and horrible violence involving ISIS in Paris, Istanbul, and San Bernardino. These cases are part of a series of cases that have been brought under this law, and then they have been, there's like some unique procedural things here, but basically in the Gonzalez case, that's the 230 case, that those claims were dismissed based on 230 and then later affirmed. And then in the Tomna case, it went on aiding and abetting liability. And so that's the reason that Twitter petitioned in that case, but that case also involved Google and Meta, who will also be arguing too. So it's kind of a unique situation, but yeah, that case is being argued the following day, and these cases are linked in some ways. Finally, Chris did a great job explaining our Florida and Texas cases. So, but really appreciate all of the support there as well. And then finally, we look forward to the court ultimately striking down these cases as unconstitutional. But in the meantime, it has not yet stopped the proliferation of these laws at the state level. Our colleagues in our that focus on state issues are, I think, as of yesterday, tracking 79 content moderation or content moderation adjacent bills in the states, with specific Texas, Florida type censorship, air quotes, bills with enforcement by the Attorney General or private right of action in at least Oklahoma, Arizona, Mississippi, Tennessee, Kansas, New Hampshire, West Virginia, South Carolina. So yeah, states are back and continuing to do. I think Chris was just in New Hampshire, where they said they were doing a first of their kind law, which was not a first of its kind, as we know now. So if he wants to elaborate on that, but yeah, there's going to be a lot of work to do and a lot of attention to these really important cases, and look forward to continuing to discuss with all of you.
Ali, let me just ask a quick question by follow-up. Did you say that the government took a position on which side of the Google v. Gonzalez v. Google case?
Yeah, so the government filed briefs in both the Gonzalez case and the Tomna case, and then they've also been asked to weigh in the Florida and Texas cases. In the Tomna case, they filed in support of Twitter, and then in the Gonzalez case, they filed topside. Didn't explicitly say it was in support of Gonzalez, but said it was in support of vacating the judgment. And I think in both of these cases, the government has asked to be a party to argue at oral argument. And so both of these cases are just the only case being heard that day, Gonzalez case on the 21st and Tomna on the 22nd. So likely to be, there are plenty of time for arguments from all of the various parties.
Again, understanding there's complexities. What accounts for their support of kind of vacating the judgment in the Gonzalez case, and on the other hand, supporting Twitter in the Taamneh case?
Great question. I think that they approach the cases differently in terms of whether they're looking at the statute versus the fact that the Gonzalez and the Taamneh case is not a 230 case, but has to do more with aiding and abetting type liability. But in Gonzalez, as I think maybe was mentioned already, President Biden has said several times about his interest in reforming 230, most recently in a Wall Street Journal op-ed. And so the administration has taken a bit of a position there. So that could be part of it, but I do definitely welcome other colleagues to weigh in on why they think that might be, if they've had a chance to read the briefs more closely. But it is worth noting that they filed on both sides, and so have some, maybe are trying to have some ones there. Yeah.
Great. No, and that'll be my first question for the whole panel after we hear from our last speaker, but let's give him his chance. Marshall, the floor is yours.
Oh, thanks so much for having me. I got to say, it's a really interesting set of questions and a really fantastic set of problems. I don't know how many know, but there was even a hearing just a couple of days ago at the Supreme Court. And rather than accepting some of these cases, they punted it asking for government approval. And I think this was their chance to buy time. Why is that the case? Because in effect, so many of these cases are actually asking the court to do opposite things, or they're asking firms to do opposite things. So in the the Gonzalez v. Google and Taamneh v. Twitter, it would be required to remove inflammatory content, versus the Texas and Florida laws, they'd be forbidden from removing inflammatory content. So these are seeking to do exactly the opposite things. And so the court effectively threw up its hands and asked for help so it could buy some time. So I'm going to try to provide what I think is a balanced view of some of these questions. I'll be honest about this, and I'm an information economist, and I'm not a lawyer, not an attorney. So I'll ask you to hold me accountable to the law, and Ari and Chris to make sure that they'll keep me honest. But I also want to see if I can give credit to some of the counter arguments on both sides. So for example, I would agree with the 11th Circuit basically with its technology friendly arguments, but I would say the 5th Circuit isn't a dumb group of guys, and there's some interesting arguments. Should it be the case that platforms are common carriers? If you were to choose as a user to try to go and receive a broad audience, where would you go if you didn't go with any of the top 3 companies? Is it a public forum? So would you want to treat them as a common carrier? So that's a fair question to ask. So I want to give 3 or 4 different points today. So the first one I'd like to make is that technology has an enormously long history of boundary spanning, or what I would call boundary piercing. The problem with this is that, especially in speech and content laws, the jurisprudence prefers strict categories. Now, is something a common carrier or is it a journal editor? Well, that's a question. That's a problem. Do you own that book, or are you merely renting the experience? Well, the technology can move it from one category to the other. Is something protected speech, or is it unprotected speech? You can say things and lie as a candidate about your qualities that you cannot do as a commercial company. And so one is protected and one is not. What's interesting about the Florida law is that you can't demote or deplatform someone who's a candidate at all. So if you want to go lie, just run for your local dog catcher, and all of a sudden they can't deplatform you and they can't demote you. So I think there's some interesting challenges there. The second point I'd like to make is that there are some deep flaws in our laws, current laws, that I believe are born of the technologies of their times. And I don't think that these are widely appreciated. Let me give you a quick example about advertising liability, and advertising is third-party content. Print is liable for lies in advertising. It's based on the 1914 FTC law. We have famous cases like this. New York Times v. Sullivan is one, but print can be liable for lies in advertising. Why? Because it's assumed you exercise editorial content and could reject them. Same thing's true of broadcast. 1934 law with the FCC. So broadcast is liable for laws in advertising, except for lies in candidate ads. Why? It's assumed that there was a limited bandwidth and you had to have a government license in order to get a broadcast. So you had to carry political candidates' ads, but in exchange, you then weren't liable for the ads that they might have. That brings us to our 1996 Communications Decency Act and Section 230, where platforms aren't liable for ads at all, and they have total editorial discretion. So we've got some differences across these categories. And ads are in fact third-party content. And even though all three business models are ad funded, they face different liability regimes. At the time Section 230 came out, AOL and Prodigy were the dominant platforms. They weren't necessarily common carriers in any sense of the word. The third point I'd like to make is I actually think we have some historical examples that we're not considering. Misinformation, I think of as a modern form of pollution. In the industrial era, we had oil and steel and railroads, and there was all kinds of messing up with the air and the water and even public life. But there it was easy to say, Carnegie, go clean up your mess, and hold them accountable for it. Misinformation is responsible for incitement to violence, terrorist activity. That's the premise of the Google v. Gonzalez v. Google and the Twitter v. Tomney cases, or lynchings, or insurrections, or other serious challenges. The two differences for the modern phenomena are, one, this form of pollution also involves speech. So it's not just chemicals, but also expression. The second part of it, I think, is greatly underappreciated. It's the extent to which this pollution is jointly created. By that I mean, one person's speech is the spark from which the amplification then becomes the other elements of it. So you might think of it as one person providing the spark and the other the accelerant. And then what happens is the neighborhood burns down, folks sell advertisements. Where does the liability rest? The person that put out the spark or the person that poured on the accelerant and actually caused the neighborhood to burn down? At the moment, there's no liability in there. So we have to be careful about how that would actually be handled. To use an example, here's some things where I think it's interesting. At the moment, because of the way the laws are written, we don't even know if any of the terrorist activity was amplified, as cases have simply been dismissed. So the process of discovery hasn't been allowed to proceed to the point, so we don't even know if there was the formation of terrorist groups or if it was recommended. So if you'd use something like the Halberstam test for the Anti-Terrorism Act, there's a wonderfully interesting example of a series of burglaries that culminated in a murder. And then the pawnbroker didn't know about it, but in fact, they were enabling the crimes that took place. So it was an interesting question of whether they didn't actually know exactly what was happening, but they then were liable for it. So would it be reasonable to hold them accountable? I totally respect Ari's point earlier about recommending the book, but extend out the metaphor to ask, where do we draw the line? So one, and I totally agree, if it's just recommending the book, then of course, I don't think they're liable at all. But now let's take the algorithm and say that it edits the content in the book and presents it in a way that encourages a particular activity. Then the algorithm amplifies it to a million different parties. Or let's go to one further extreme where the algorithm starts to assemble a group that assembles Molotov cocktails. Once we'd gone all to that one, we probably would want to hold them accountable. Now, I'm not accusing the technology companies of anything like that. I really highlight everything makes this a spectrum, which makes this a really, really hard problem. I also agree, in general, we got a really hard time because we want to protect free speech, we want to protect accountability. So how would we do it? And let me see if I can recommend a couple of, so where are the problems?
And quickly, Marshall, if so we can get into our discussion with everyone.
Well, okay, wonderful. So the problem with this, if we hold them accountable, they might chill speech and take too much down. Another is that there's a challenge of impossibility at scale. Can you deal with 500 million messages a day? Let me give you a couple of thoughts of possibly doing something about this. Number one, separate original post from amplification. You could protect original post even more than is done now as part of free speech, so that you could actually give conservatives more of the viewpoints that they want. So you could protect the original more. The second would actually be to handle the flow rate of the pollution. So you do a statistical sample, not the entirety, not individual messages. A doctor doesn't check your cholesterol by taking all your blood. They'll take a statistical sample. We can use the central limit theorem to know to any level of certainty that you want by taking a larger sample of this to know how much some activity has been promoted. So we separate the two, we use a flow rate. A second change that I would recommend for Section 230, this one should be simple: treat all people equally. It is the case, for example, that there were exception lists and some people were allowed to post inflammatory content that the rest of us were not. So they're violating their own terms of service. So simply treat all people equally as one in there.
Let me go ahead and move into a discussion with all of us. Okay. And I see 3 hands are raised, which is great, but I want to start us off with a question, which is, given the Biden administration's starting to take a position now, mind you, President Biden,
Yep.
before he even was president, did say he's opposed to Section 230, but the rubber hasn't hit the road until now, apparently, right? And so the points that Ali, that you raised earlier, I think are really salient. And my question for each of you, again, starting with those with your hands raised, is the Biden administration really going to do as Chris says and take the position that the Florida and the Texas laws are unconstitutional infringements of the First Amendment? And how do we navigate the fundamental challenge that Ali and Marshall have raised, which is one set of laws or one set of cases is dealing with stopping the tech companies and being more hands-on, and the other set of laws is saying be more hands-on. How do we reconcile that paradox? So let's go with the order here, Ari, Ali, and Chris, to that set of questions.
I think that Biden's tech policy is actually largely incoherent overall. I don't know what I would expect the Solicitor General to say. It's hard to tell. It's also hard to read tea leaves when it comes to the Supreme Court and the call for the views of Solicitor General. It's really hard to say what they're doing. I do suspect they're trying to bide time. And one thought, and I say this having just said it's dangerous to read tea leaves, is that it is theoretically possible that if they do enough monkeying with Section 230 and tinker with it in ways that are not actually before the court, in terms of, say, the difference between 230C1 and 230C2A, it could theoretically impact whether or not the Texas or Florida laws are preempted by Section 230, which again, also not the question technically before the court, but they could just go there anyway, because who knows with this court. So it's going to be really interesting to see. I don't know what, Marshall, I would say on the common carrier question, I had M put a link to our Fifth Circuit brief, which does a rundown of why they aren't common carriers. I would also say with respect to an algorithm that edits, when a platform edits something and that contributes to the tortiousness of the tweet, that is already unprotected by Section 230. If Section 230, or if a platform had an algorithm that promoted my tweet that said Chris Marchese did not murder my dog and takes out the did not part, that would turn it into a defamatory statement, and the platform would be liable because its algorithm did that editing.
Thank you. Yeah. Let's go to Ali.
Sure. And I don't know, can we go over, there's so much to talk about. I put my hand up before because I just wanted to mention something that came up. I wanted to just flag the briefs that CCI and NetChoice and some other groups filed in these 2 Supreme Court cases, just to talk about all of the work that citing the various companies' transparency reports, and talking about all of the work that they do, specifically focus on terrorist content, because that's what these 2 cases are focused on, and how some of the companies are able to take down the vast majority, more than 90% of content before anyone even sees it. And so all of the investments that are done there, as well as the challenges with content moderation at scale. And because I already talked a little bit about the government's briefs, I'll let others do so because we're running out of time. But
okay, thanks for being brief. Chris, you're next.
Thank you. So Marshall made a lot of really interesting points, and I would love to respond to all of them, but I'm just going to kind of stick high level here and point out that since the beginning of this country, our newspapers have always been highly partisan. In fact, the earliest newspapers that the founding fathers themselves created, including Alexander Hamilton's The New York Post, were basically just propaganda organs for the, burgeoning political parties. And they were not really reputable sources of news. And yet they still received robust First Amendment protection because since the very beginning of our country, we have always kind of understood the First Amendment to protect speech that is advancing somebody's views, even if those views are not necessarily fair or not necessarily views that society as a whole would deem worthy of everybody's time and attention. but that is the First Amendment we have, and thank God we have it. And something to bring up in terms of, this idea of our social media businesses so different from newspapers that we should have a different liability regime for them, or to have the same liability regime. I would just point out that if you are a private business or a private individual, you have a First Amendment right to moderate content as you see fit, or to be a little bit more precise with the, legalese, you have a First Amendment right to editorial discretion. And I think this is really important because this right applies not just to individuals, not just to newspapers, but also to, what we today might think of as common carriers. In the 1980s, the Supreme Court held that public utilities have a First Amendment right not to be compelled to transmit messages that the state of California wanted the utility company to transmit. And so if a utility company that has a, government granted monopoly over a state's electrical grid has a First Amendment right not to, share the state's messages, I think we can safely say that Texas and Florida do not have the ability to force our private businesses to, carry political speech or any type of speech that they don't see fit. And I think this is very important because if you start treating social media businesses as different from other forms of media, you're shutting for viewpoints to flourish in the marketplace of ideas. And that also includes viewpoints that have been moderated by private speakers. And I think that this is really essential to point out, because if you start making exceptions and you say, well, you know what, Google, or you know what, Facebook, you're the new public square, and therefore you don't deserve as many First Amendment rights as, the New York Times or the Wall Street Journal. Well, what are you basing that off of? Because the New York Times and the Wall Street Journal are also for-profit businesses, and They are owned by conglomerates, right? And so I don't know how you can, under the First Amendment, do any of that. But just to wrap it up, to be polite here, I'll say, I think whether it's Section 230 or the First Amendment, ultimately what this comes down to is that the line drawing has to be done by the individual speaker, right? Nobody on this panel has all the answers. Nobody in our society has all the answers. But the First Amendment tells us that it is the speaker who gets to make the decision.
Let's hear from Marshall and then Jessica, and then I'll have one last final question and give everyone's feedback on that. So Marshall, anything you want to weigh into? You got your hands up, and then Jessica, let's hear from you.
Indeed, love to do that. So actually, I want to combine some of the comments from Ari and Chris. In a sense, I totally agree with everything that's been said. I totally support that they should have the editorial responsibility. They should be given the freedom to say, you want to support a diversity of ecosystem views. That's another reason why I would protect original posts even more than is done. But the way you guys are implementing it leads to a paradox. You also admit that Section 230 doesn't protect terrorist speech. It doesn't protect criminal activity. There are even special carve-out. Section E doesn't. It specifically says it carves out the intellectual property. It carves out in criminal activity. But the problem comes in when it's used to block even the process of discovery. So you can't know if the algorithm has actually been doing the amplification. So hold them accountable for actually engaging in the criminal activity or promoting the criminal activity. Ought to be able to at least have the transparency to know in order that you can then hold accountable. So I would totally agree with all that, but then you need to allow the transparency to hold folks accountable when the speaker or the editor does things they shouldn't. And we need to be able to know when they have done so.
The government can get a warrant.
The second point I do want to make, I actually totally agree. The moderation should be done by the speaker, by all means. The speaker is absolutely the party that we really, really should be doing this. And I actually think better ways of doing this will be finding regimes in which the speakers themselves are more accountable for what it is that they've said. I want to give them both the platform, give them the visibility, but also the transparency by which we can hold bad speech accountable when it causes insurrection, when it causes terrorist activity, things of that sort. So you and I both know, by the Brandenburg Standard, you can do anything to legitimize violence up to the point of instigating violence. The problem is that there are so many activities that are on social platforms starting to legitimize violence, and then someone else makes a spark to actually tip it over. So we still need to try to hold some of that accountable.
Jessica, can transparency help us out at all here? You're on mute. You're on mute, Jessica.
I hope so. I mean, I don't know how we can make any decisions about anything if we don't have information that we need. So I would just, I'm absorbing so much of what the other panelists are saying, but I do think that there should be some requirements about sort of understanding how companies are enforcing their own rules, releasing data about that. There's got to be more transparency in how the systems operate. And again, to drill home the point that we're always trying to make at RDR is that privacy and data protection are actually more fundamental now to free expression than they have been, I think, or, just given the way that the internet works and the data that's collected. And that we have to have more insight into how companies are collecting data and then using that data to actually amplify, recommend, rank content, and get it into different people's hands. So there just has to be more transparency, because otherwise I'm not sure how we make informed decisions.
All right, the time has flown by. We'll do one more round of questions. I'll give a final question, but you can also tack on anything within reason. And let's go in reverse order from the way we started. Okay, so we'll start with Marshall here. And so my question for you now is, what is your suggestion for reforming 230, if there were reforming, in quotes, if you had to do something to change it? And granted that we've got lots of moving parts here. We've got 2 Supreme Court cases that are sort of saying, tech, you didn't do enough, and the other 2 potential cases, tech, you are doing too much to clamp down. Then we have Congress, which we haven't talked a lot about here. We have the Biden administration. We have other state legislatures. So there's lots of vectors and lots of players. But if you were the philosopher king and you could change Section 230, how would you change it? And so Marshall, and then we'll go from there to Ali, Jessica, Ari, and Chris.
3 quick ideas. One is make sure they enforce the rule, treat all people equally. So there's no differences across different users and different exceptions across different users. And we have the transparency to do that. Second, I would separate the original post and protect that more, and then hold them accountable for the amplification. But I would do so on a flow rate basis. I do agree that it's impossible to do on an individual message basis, but you could know to well beyond a reasonable doubt, to any level of certainty required by the central limit theorem, a sampling of how much is getting amplified of damaging speech. So in conjunction with that, I would also argue third might be, if you want editorial authority, just accept responsibility for liability for your share, not the whole thing, just your share for the amplification. If you want the common carrier exemption, then create a true marketplace. This is a case where you'd get even more voices inside. So if they chose on their side the common carrier liability, create a marketplace where users could choose moderation by Fox News or by BBC or by Consumer Reports. At the moment, the only moderator you have is Twitter or Facebook or Google. So in exchange for this common carrier protection, create a true marketplace where more voices could flourish. So there's 3 ideas for you.
Well, thank you. I want to follow up on that third one, but I'll do it offline. Let's hear from you, Ali.
Thanks. So just a few quick points. One is that from my perspective, Section 230 already creates this great opportunity for vibrant marketplace without barriers to entry. There's because any website, not just a handful of social media firms, all benefit from the protections under 230, and so any attempts to change it could risk the entire internet ecosystem. Services, so smaller services and startups do not have the resources to, that other more leading firms may have, and so it's just being mindful of the implications for all different types of and sizes of businesses and websites. And then on the question on 230, I would point to Senator Wyden, one of the 2 co-authors of Section 230, along with former Rep. Chris Cox, who also filed a great brief in the Gonzalez case. But what he said, his test on Section 230 legislation or reforms is any changes to Section 230 shouldn't target constitutionally protected speech, and they shouldn't discourage moderation, and the bills that he's seen so far violate one or both of those things. So I would agree with that too. Thank you so much.
Thank you, Jessica.
I guess, well, I wouldn't advocate for changing 230. If I had to sort of make a suggestion for something that something else. It would be, again, sort of looking more at regulating ads. I think the problem that we're facing needs to be broken into smaller pieces. And I don't think Section 230 is sort of the level at which that should happen.
Right. Very fair point. And thank you for being with us and offering your thoughts. You've had your hand up for such a long time, Ari. Give us a piece of your mind here.
I always got something to say. I'm with Jessica. I don't think it should be changed at all. If there are changes to be made, change the federal criminal law where necessary and give the government more resources with which to prosecute crimes. I will say to Marshall that the exception for criminal activity isn't hampered at all by Section 230. The government can get a warrant and get all the information it needs. It doesn't need any kind of notional legislative transparency. The government can investigate crimes without encountering 230 at all. And the incitement question is just kind of similarly say, things that quote unquote lead to insurrection don't necessarily count as incitement. The amount of things that could possibly be incitement on social media, it's not impossible, but it's extremely limited there.
I got to correct
sure
what I do think is an error. If I'm not mistaken, and again, you have the law, I thought in Twitter v. Tom now, or Google Gonzalez for Google, they have not been able to engage in the process of discovery. So they've sought it and they haven't been able to get the information because it's been dismissed.
But
so
that's
they have not been able to get that data.
That's not under the criminal law exception. That's a different story altogether. Criminal law is criminal prosecution.
In effect, you've ignited that there is this exception where they have not been able to get the data they needed.
Yes, one of the benefits of Section 230 is that it provides for early dismissals with cases that Congress has decided are not the liability does not properly belong to the platform. That is by design. That is entirely
and so it's okay if it were promoting terrorist activity in the background, but we don't know.
I mean, if they had any kind of evidence, I'm not sure that we'd even be here. I mean, I'm not sure what the question is here because it's
right.
This is a primary point of Section 230. This is by design.
Well,
and it's the liability doesn't attach, evidence or not.
And this is our final argument stage, if you will. So, counsel, please proceed and finish your points, Ari. So
okay, fine. The very last thing is I would be very wary of any kind of government regulation about limiting things based on the flow rate or anything like that. The government has no legitimate First Amendment interest in it stopping the flow of otherwise protected speech.
Great. You get the last word, Chris. Tell us a little bit on your thoughts on these other two cases and the broader question I asked you about changes to 230.
Sure. So I'll start first with the second question. I agree with Ali, Ari, and Jessica. We should not amend Section 230. That being said, if I had to, I would say I would add a little footnote saying explicitly that it applies to algorithms to kind of prevent the current fiasco that we have at the Supreme Court. But otherwise, I think Section 230 is a great law. I think it's a commonsensical law. And, to Marshall's points, what all Section 230 does is enshrine common sense liability provisions. It says the person who creates the wrongful content is the person who should be held responsible. I don't know anybody who could disagree with that. Now, in terms of, where do we go from here? I would say, well, maybe Section 230's common sense liability provisions should be carried over to other industries. Perhaps the news industry, the traditional media, deserves their own type of 230 protection. Now, to be sure, they already have the Supreme Court, decision in the New York Times v. Sullivan case, but I'm open to exploring statutory protections for other industries to help facilitate free speech. And I think that that's where the conversation should go instead of trying to take away the law that created the internet and that allows free speech to flourish. And I'll end by saying, Section 230 is working. It has worked. It continues to work. The internet we know today and love is because of Section 230 and the First Amendment.
Very, very interesting final thoughts. Instead of a ratchet downward, a ratchet upward, and consider those protections for other industries instead. This has been wonderful, and thank you for being with us as we went over time just a little bit. Join us next Wednesday for what will the 118th Congress do on broadband and big tech, and the week after on the Build America, Buy America's Laws impact on infrastructure. And don't forget to mark your calendars for March 9th. That's the date for the Big Tech and Speech Summit at Clydes of Gallery Place, all-day event, March 9th, 2023. On behalf of our great panelists, Chris Marchese, Ari Cohn, Ali Sternberg and Jessica Deer, as well as Marshall Van Alstyne. Thanks for giving us a contrarian point of view. On behalf of each of you, I'm Drew Clark of Broadband Breakfast. See you next Wednesday. Take care, everybody. Bye-bye.
It was a pleasure. Thank you.